Information in this video should not be considered as a legal opinion in any way whatsoever and does not establish a client-lawyer relationship. This content is not intended to be a substitute for professional legal advice or opinion. Always seek advice from lawyer personally regarding your specific legal issue. Hi, welcome back to GMR Law Associates. Today our topic is, how to make a valid will and 9 important points to be considered for avoiding legal disputes. This topic is selected, as many of our viewers requested us to make a video on how to make a valid will and important points to consider, hence this video for the benefit of the viewers. Please watch the video till the end, so that you will not miss out any important points. Most of the points are explained in and all the way. We will be giving you important tips especially at the end of the video. So watch the video till the end without fail. Let us go on. Importance of making a will. Will declares that how the property of a person is to be distributed after his demise. A valid will eradicates the chances of disputes about the properties of person after his death. In the absence of the will, the property will be divided according to the Hindu succession law for Hindus and Mohammedans according to the Muslim law. What is a will? Will means the legal declaration of the intention of a person with respect to his property. A will made by a Hindu, Buddhist, Sikh or Jain is governed by the provisions of the Indian Succession Act, 1925. However, Mohammedan are not governed by the Indian Succession Act, 1925, and they can dispose their property according to Muslim law. It is a unilateral document and takes effect after the death of the person making it. It can be revoked or altered by the maker of it at any time he is competent to dispose of his property. Who can make a will? It is important to understand that a will can be made by a person who is a major, I mean above 18 years of age. Making a will should be a voluntary act. The person should not be mentally challenged at the time of making will. The person making will must have knowledge of contents of the will. A person can make will with disability of impaired hearing or vision or speech. The person making will should be free from undue influence, fraud, coercion, intoxication. What does will deed include? Will can be executed on a plain paper. Will does not need any specific form or specific language. Will must disclose the intention of the testator about dispositions of his or her property or properties. Will must include the details of the property or properties. Will can have a statement of appointment of executor. Will must be signed by the testator before the witness. Will must have the signatures of the witness. 9 important points to be considered. To avoid legal disputes in future. 1. Will should be made by an individual. 2. Will is valid only when made for self-acquired properties, you cannot include ancestral properties. 3. Preferably will should be prepared in own handwriting. 4. Do not forget to mention page number, example 1 of 3 for every page of the will. 5. Ensure that no corrections are made in the entire will document. If it needs any corrections or modifications, please prepare new one without corrections. 6. Ensure signatures of 2 neutral witnesses, preferably lawyer or doctor or a reputed person. 7. Ensure that the beneficiary cannot be executor or witness in the will.
8. Ensure that the preparation date and signed date should be same on the will by the executor and witnesses.
9. It is not compulsory to register a will but recommended. Frequently asked questions. Question: can I cancel, revoke my will and how many times? Answer: yes. You can cancel your will as many times as possible until you are alive by making a new will and mentioning that you are canceling or revoking your previous will. Only the last will is considered to be valid. Question: can I mention about my bank accounts and digital accounts in the will? Answer: yes, you can mention about who can withdraw money from your bank and who and how to manage your digital accounts after your demise. Frequently asked questions. Question: can I exclude my son or daughter or any heir as beneficiary from will? Answer: yes. You can exclude as the properties you are including in your will are self-acquired properties. Question: do I need to pay stamp duty for my will? Answer: no, if you are making it on plain paper. Yes, if you are registering your will. Question: can I make a conditional will? Answer: yes. Please contact lawyer for getting it done properly. Frequently asked questions. Question: can I make a will on ancestral property? Answer: no. Question: can I get my will prepared by a lawyer? Answer: yes. In most of the cases, will prepared by own without an expert lawyer does not contain all essentials of will and many times ruled as invalid by the courts. A simple example would be of ambiguous language, hence it is recommended but not compulsory to get a will drafted by lawyer. Thank you for watching the video. Please do not forget to subscribe the channel and like this video.